Lawyers Solictors, what is the strangest or oddest law that's won a case for you? Rumple off the Daily said. The Canadian Interest Act specifies that all interest must be specified in a per annum percentage. If it is not, it's struck down to 5% simple interest per year. The number of lenders and creditors who try to pull off a 4% monthly compound interest, but aren't familiar with the provision of federal law. Rumple off the Daily said. Shady outfit offers to sell you a used car with an interest rate of 3% per month. Neglects to mention that it's 36% per year. Debtor makes payments that they think should equal out to the correct value, only to learn that most of their money went toward interest. Demand letters and claims tended to go away quickly upon faxing over that page of the statute. Milkshake said. 47 U.S.C. 227, b. Restrictions on use of automated telephone equipment. Law student working at law firm. We have a fax machine that gets tons of spam faxes. Our chief partner has a vendetta against spam, and he uses it to give us practice in researching and writing petitions. So we catalog each fax, send replies to take us off the list, document everything and wait for them to fax us again. Then we follow up with the FCC complaint and demand letter. A couple times this has ended up with the person getting mad and sending us retaliatory faxes, black sheets of paper. If they stop sending, we don't do anything, but we've gone to small claims a couple times and gotten $500 per page a couple times. We also got someone trying to sell drugs through fax, but we just turned that over to the police. Fattyesq said. I won a case where the defendant, New York City, tried to exploit a really stupid law, which I was able to use to win the case. This was a slip and fall case where my client had tripped on a piece of broken sidewalk outside of the Natural History Museum and shattered her arm and wrist. The law is that a property owner is responsible for the sidewalk directly outside of their property, the theory being even if they can't fix it, they have a duty to warn people about hazards and mark the area off. The museum was owned by the city. There's another concept called sovereign immunity, which is that governments can't be sued without their consent. So the city had passed a very stupid law that they would be exempted from the rule that they can be sued for sidewalk injuries unless you can show they were on notice of hazard. Meaning, you would have to show that you informed the Secretary of State, Governor, Mayor, etc. of the exact specific crack in the sidewalk before the injury occurs, and you had to do so in writing with ample time for the city to remedy it, 180 days in advance AskReddit. Under normal circumstances, this is impossible because no one anticipates tripping on the sidewalk 180 days in advance with the foresight to write a letter to the mayor about that specific crack. Luckily, someone did have that foresight, and there was a non-profit called Big Apple Maps which would go around the city and with maps of government property and record with insane specificity each and every crack in the sidewalk, pothole, protrusion, and other hazard, and then publish these maps while serving copies on the government, with the express purpose of combating sovereign immunity defenses in slip and fall cases against the government. I got a hold of one of these maps and visited the site, and I was able to take pictures of the section of the sidewalk where my client fell, and you could see newly placed concrete over the area in the exact position indicated on the map, showing where the sidewalk had been repaired after my client slipped. Basically, the government's attorney brought up the sovereign immunity defense and outlined all of the stupid steps I would have needed to go through to overcome their motion to dismiss. My response was, "Oh, you mean this?" and gave them the map. Immediate settlement. Clamorial said. The number of times I've told younger friends to just file the damn report anyway, whether it's with town hall, the apartment complex, landlord, super, the cops, or whatever relevant authority or whatever. This is exactly why. The answer to what are they going to do is probably nothing, but this way you can rob them of their smarmy recourses, establish a pattern, show diligence and responsibility, and other things that will look great in your favor should you ever end up in front of a judge. A little bit of SIA insurance can go a long way. Regulatory capture said. Yup, for everything. Bike got stolen in a big city? No. The cops aren't going to come dust for prints and have a detective work the case. They aren't even going to come to the scene. But filing the report does many things. Forces them to include it in their crime stats. If enough people do this, that's how you get some sort of bike theft task force to set up bait bikes and catch a few people. If they do randomly bust a bike theft ring and recover a van full of bikes, you might actually get yours back, especially if you saved a picture of the serial number, rather than it ending up at a police auction and getting resold. If you find your bike, it is 10x easier to do something about it. See it locked up on the street a year later? See someone selling it on Craigslist? Call the cops and bring up your police report. It doesn't take very long to file the report, and don't let them try to talk you out of it. Sometimes they don't want to bother with the paperwork because of reason number one: it makes them look bad when there's more petty theft in the crime stats. Fattyesq said, "Honestly, it's because the government is too lazy to do it themselves. The theory is that the property owner has the duty to monitor and warn guests, because they're always on the property and are in the best position to keep watch. They also have the duty to contact the city to have it fixed. The duty of fixing the sidewalk is separate from the duty to warn guests about it. Another example is snow. Owners have a duty to shovel snow on the sidewalk adjacent to their properties." Fattyesq said, "So in New York, evidence of subsequent remedial measures is only inadmissible if used to show negligence or culpability, but it can still be used to show something else, including notice, control, or the existence of the original defect. So I was going to use it to show that the defect was actually where the map said it was. If you can imagine, the sidewalk was lightly colored, and then you could see this thin, jagged line of darker colored cement over top of a portion of it, and I basically matched that with what was on the map only to show that it had, in fact, been cracked. And the map was dated, because Big Apple Maps was awesome and they dated all of their maps and periodically updated them. So we had a map of before the incident, a map after the incident, and the actual picture of the newly laid cement to just corroborate the maps. Of course, it didn't get that far because as soon as Corp Counsel saw it, they caved." Malthus once said, "The weirdest case I have ever dealt with was Jolie v. Pollitier, 1999, OJ. Number 1728, SCJ. I did some research for this case when I was a law student. Some background: this was at a time when the Ontario Court of Appeal had held that, if there were any factual matters in dispute, a case could not be dismissed on summary judgment. That is not the case today. It was discovered that this position basically ruined summary judgment as a useful process, but it was at the time. In such a motion, all facts alleged by the plaintiff would be assumed to be true. What happened was this: a man sued, among others, the College of Dental Surgeons, for persecuting him and interfering in his ability to live as a generic Martian. The plaintiff claimed he had been cloned from space debris NASA found in the 1960s. He claimed he had a genetic test to prove this, but it had been falsified by the CIA as part of the conspiracy against him. Well, naturally, this claim raises the concern that the plaintiff was bonkers, but there was no evidence, aside from his bizarre claims, of that. In court, the case was decided on two alternate grounds. First, on the boring grounds that the case was patently frivolous and vexatious because it was absurd. However, it was also decided on the more entertaining basis of standing. Justice Epstein held that only a person could commence an action in Ontario. The rules of civil procedure define a person to be either a human being or a corporation. The plaintiff's whole case was based on him being a Martian. If he was not a Martian, his case had no merit. If he was a Martian, he lacked standing to commence a lawsuit in Ontario. In short, we now have precedent that Martians cannot sue in Ontario. PVT Death said, "There was a case here in Hawaii that got thrown out like this. Someone got pulled over because the police saw she had way too many passengers in the car. Then they noticed she was drunk. Open and shut case. Well, apparently in Hawaii, there's no law defining the maximum number of passengers in a private vehicle, so the issue was that all the extra passengers weren't wearing seatbelts. Well, this failed also, because the law only says that every available seatbelt needs to be in use. If you have 6 passengers and only 5 seatbelts, there's nothing at all illegal about the 6th being unrestrained. So, since there was no probable cause to pull her over in the first place, even though she was indefensibly drunk, the whole thing got thrown out. Hawaii has some very counterintuitive laws. If your truck has seats installed in the bed, your passengers must be buckled up. If not, they can just party back there, while anyone in the cab unbuckled would get you a major ticket. People regularly ride down the freeway in truck beds while sitting in lawn chairs." Brosantium said, "I had a roommate who got picked up for public intoxication one St. Patrick's Day. He was in jail for a couple days, which seemed odd for a pie. Turned out he had a warrant from another city for escaping jail. The year before, he got picked up for public intoxication on St. Patrick's Day. He had a hazy memory of being shuffled down a hallway with a bunch of other drunkards at the jail before walking through a door and suddenly being alone outside. From there he just walked home. The police never came looking for him, so he wasn't even sure it happened. Anyhow, it turns out they never even properly booked him, so while there was a warrant for him escaping jail, there was no record of him ever being arrested. Case dismissed. NIOP 4 said, I have one where we won, but didn't quite go as planned. I had a client a while ago who was incarcerated at a state prison farm. Inmates had to spend 40-60 hours a week preparing slop for the hogs from expired restaurant food, and cleaning the hog barns. He reeked every time I met with him, even after showering. He said it was miserable. Well, he found out that some Muslim inmates, who couldn't work with pigs, were offered to be able to work at the police horse stable instead, 5 minutes down the road. He wanted to sue, saying that stable work is much less revolting than hog work, and that this amounted to unequal punishment on the basis of religion. I thought he had a point. Well, the case didn't get thrown out and actually got some traction, but then the prison changed their policies in response. Inmates who couldn't work around pigs, or didn't want to, would instead be transported to a factory chicken barn the next county over for work each day. He asked that I drop the lawsuit, and the Muslim inmates were not happy with him. Atlantis Airlines said, I never have and hope I never will. I worked on farm that only had a few hundred and that was horrible enough by itself. One of my coworkers had worked in a chicken factory during his childhood summers. His job was picking the remains of dead chickens from cages. To prevent fecal buildup, the cages had mesh floors and occasionally a chicken would collapse from some disorder or whatnot and the rest would just walk over them, slowly pushing their body through the mesh. Night Toxic said, my brother is a lawyer. He got a DUI charge dropped for a client. Guy gets pulled over, cop asks him to step out to perform the sobriety test after he admits to having consumed some amount of alcohol. He complies, but after stepping out of his car asks the officer if it's okay for him to reposition his vehicle to move it further away from the road because he feels uncomfortable being that close. The cop obliges. Apparently the charge got dropped because the officer willingly let an intoxicated individual operate a motor vehicle. Fin 425 said, this happened with a guy I know on his boat. He has a huge 65-foot Viking and the cops couldn't dock it, so they asked him to. His lawyer shows up and says the cops made my client dock his own boat after they decided to take him in for DWI. Sober Water Patrol couldn't dock the boat, but an impaired person can. Case dismissed. Drambox said, a friend is a DUI attorney in NY and got a case dismissed because the trooper perjured himself. Long story short, it came down to the trooper testifying in open court, under oath, obviously, that he'd witnessed that the key to the defendant's car was in the ignition when the trooper approached him. My buddy asked the trooper 2 or 3 times if he was absolutely certain and then asked the trooper what make and model the car was. Toyota Prius. And this was the model that didn't have an ignition slot for the key, just proximity detector. South Seattle 77 said, over 10 years ago, I had been at fault for rear-ending someone else. I had no insurance and my license had expired. I don't think I need to mention that I was in a very destitute, low place in life, struggling with almost every conceivable aspect of living. The cop was very kind as we talked, but wrote me a ticket for it all. One was kind of a fixed ticket about my suspended license. I sorted that out in the days after and nothing came of that ticket. The cop had mentioned that he had to write the insurance ticket, but to take it into court and get it lowered. I was desperate to try and get my $800 insurance ticket lowered because I couldn't afford something like that. So I took the cop's advice. I went into traffic court weeks later, and when it was my time to chat with the judge in front of everyone there, the judge looked at the ticket, stopped me and said, I would like to use Mr. South Seattle's case as an example to the gallery. I almost died. He went on, this is a court of law, but it is also a court of fairness. It seems as if the officer didn't write the date of the incident in the ticket. I can't hold Mr. South Seattle accountable to this. My jaw dropped. I stood there. The judge told me I was free to go twice before it registered. I'm pretty sure the cop deliberately didn't write the date on that ticket. Thanks, officer. I miss pasta, Sabed said. Typical INL, but the first and only time I ever used the subway station's emergency door to get to the train, the exit gate wasn't working. It was 3 a.m. I was a drunk college kid trying to catch the last train home. I got caught by 2 subway officers and given a ticket with a huge attempted fare avoidance fine. I showed up to the hearing in desperation, and they ended up having to drop the fine as they were reviewing the case with me because one cop had recorded that I entered through the right-hand emergency door and the other wrote that I entered through the left-hand emergency door. Never been so grateful in my life. Thaddeus Jones said. In 2016, prison inmate John Modi was charged with escaping from the prison in which he was incarcerated, which is a crime in Ohio. The prosecution, however, failed to establish that the Hocking Correctional Facility, and therefore the crime, was located within the court's jurisdiction of Hocking County, as all witnesses potentially able to offer testimony on the person's location had gone home for the day, and, incredibly, no one remaining could provide references allowing the court to take judicial notice of the prison's location. The charges against Modi were dismissed, and he was allowed to return to prison to serve his sentence, but at least without additional charges concerning his alleged escape. Strug said. I had a family friend, old guy, passed away now, who said that he was able to escape from prison and because he escaped, was let go, because no one was supposed to be able to escape from the prison, or something like that. He sometimes told stories, but the few things he told me about his crimes, major theft, I didn't believe but later saw the court papers and they were true. He was a jailhouse lawyer and had a whole bookshelf of legal books. If anyone would be able to research and tell me if it's true, PM me and I'll give you his name because I'd love to know. I don't recall which prison it was, although I know he was in Arkansas for at least part of his stay. Edit. Someone is looking him up for me. I'll update if there are any results. B0 Winder said. Submitting a survey or a map would be evidence. To submit evidence you must lay foundation, which in this case would be someone with subject matter knowledge having to testify to the veracity of the documents. Additionally, you would have to give the defense time to prepare for any evidence or witnesses. That is basic discovery. Regardless of what TV and movies show, there are no trial by surprise. No surprise witnesses. No damning or exculpatory pieces of evidence introduced at the last minute. This is the type of stuff pro-se litigants have no idea that are coming. Every fact needs to be established, even something obvious like does the court have jurisdiction here? I'm a lawyer, corporate, in-house, glorified businessman stuff, and I would get so much shit wrong if I ever had to litigate something. In fact, I am currently waiting for a real litigator to come and tell me what I got wrong here. Edit. I would also like to mention a court can take what is called judicial notice. That is when a court takes a fact as true without presentation of evidence. Here is where I would need a litigator to tell me if both parties must stipulate to that or if a court can act on its own. Elender said. Had a case where my defendant opponent filed an appeal from an administrative agency to the local circuit court. The requirements for filing the appeal are very strict, and the filing must include an appeal bond, executed by the individual defendant, or a corporate officer. When my opponent's assistant electronically filed the appeal, she attached a .pdf of the bond without the corporate signature. There's no question in my mind they had the bond with the requisite signature, and simply attached the wrong version of the document to the filing. Wish I could say there was a huge court fight over this, and I got to slam my opponent, but that's not how this works among professionals. I waited until after the time to correct this error had passed. I then politely called my opponent, told him that I was holding the I win button, and that I'd be filing a motion to that effect in a week. My opponent came to me with very favorable settlement terms within days. To this day, I don't know for sure if my opponent ever disclosed his mistake to his client. But I doubt it. Beaton said. This is a pretty easy one for a civil case emo. Lawyers must act reasonably and to a professional standard. Lawyers also can't lie to their clients, or the courts, and can't lie by omission when they know it's an important detail. Checking that documents are signed properly before submitting them to the court is a reasonable, rational step you expect a lawyer to take. If you lose a case or are forced to settle because a lawyer didn't check signatures, the lawyer is at fault and they usually have mandatory big old insurance to handle it, similar to doctors. If they didn't inform the client that they screwed up as well, oh boy. It might shock you how often missing signatures, pages, details, and documents comes up, even though it often requires like 8 fuck-ups by secretaries, law clerks, lawyers, various levels of staff at the courts accepting the documents, etc. Rain Bucket said, lawyers carry malpractice insurance. If you retain a lawyer for a civil matter and they make a mistake, like filing the wrong thing with the court, that ends with you losing your case or the limitation period to file a case expires, you can then turn around and sue your lawyer for screwing up. If it was the lawyer or their staff's fault, then their malpractice insurance will pay a settlement or judgment so you can get paid what you reasonably could have been awarded if your civil case had been successful. It's a huge breach of rules and ethics for a lawyer to screw up like that. A fair number of complaints to the bar about lawyers is about them missing court deadlines or making mistakes with pleadings and other paperwork. I'm less familiar with how it works in criminal and family cases. I think you can appeal the courts with a new lawyer based on having ineffective legal counsel at the initial trial in criminal cases. I don't know if you can do that in family law. Family law does usually have more options to file with the courts to have things reconsidered over the years, so it may have its own procedures to fix your lawyer's mistakes. Bike Chain 96 said, not a lawyer, but I got a charge dropped because of the cop's bad handwriting. I got a ticket on a Monday night for speeding, and was given the court date of like 2 months from then. About a week and a half later, I get a letter in the mail that I'm being charged with a failure to appear for court. I'm in court 2 days later for that, and tell the judge not guilty on the FTA, and no contest on the speeding. After asking him to just look at the date on the ticket and my supposed original court date, he sets them down and goes, you have a point there. Not guilty on the failure to appear. And how do you plead for the speeding charge? I replied, no contest. I was speeding, Your Honor. He looks at the ticket, sees that the cop had initially put 10 over and in the notes put my actual speed, like 20-30 over, and goes, yes, it certainly looks that way. LOL. Call 84 said, I once had a client who woke up in the middle of the night to the sound of someone in his home. He retrieved a Colt 1911 from a bedside drawer, walked into his living room and confronted a figure in the dark. The person didn't identify himself but moved towards my client, who fired a single shot that went through the person's shoulder. Turned out it was my client's stepson, who had snuck out, been drinking underage, and stumbled home. The problem with the situation was that my client was a convicted felon. Several times over. That meant that while the shooting itself was legally defensible, his possession of the firearm was not. We looked into the history of the gun itself, as our client had indicated it had belonged to his grandfather, who had served in the U.S. Army in the early 20th century. Ultimately, we were able to bring multiple experts in and establish that the gun had been among the very first batch of firearms distributed from Colt to the U.S. Army at the Augusta Armory. Florida Statute 790.001 creates an exemption of firearm-related laws, including the prohibition for felons to possess a firearm, if the firearm in question was an antique, meaning it was manufactured prior to 1918. Since we could establish the history of the firearm to have been manufactured before 1918, our client couldn't be prosecuted for the offense and got out from underneath a potential mandatory prison sentence. Tuska the Demon Killer said, had a client who was a truck driver. He got various penal infractions for issues with his truck. Several $1,000s in fines basically. Anyway, the evidence is pretty damning. Lots of pictures showing defects, detailed description by the traffic control officer, and so on. However, to find him guilty, the prosecutor technically has to prove that the vehicle he was driving is considered a heavy vehicle. The law says, 3. Heavy vehicle means a road vehicle or combination of road vehicles, within the meaning of the Highway Safety Code, having a gross vehicle weight rating or gross combination weight rating of 4,500 kilograms or more. B. A bus, minibus or tow truck, within the meaning of that code. C. A road vehicle subject to a regulation made under Section 622 of the code. The traffic control officer had not listed the weight of the vehicle in his report. There's pictures of it, clearly an 18-wheel truck, in the report, but no weight written anywhere. So, I told the judge that the prosecution hadn't proven the weight of the vehicle per the definition of heavy vehicle. The pictures don't prove the numerical weight, just the shape of the vehicle. She had no choice but to acquit him because all of the infractions he had received were for a heavy vehicle operator, so he can't be guilty if they can't prove he was operating a heavy vehicle. Prime 67 said, had a family member get a DUI. He was sleeping in a parked car on the shoulder of a rural road across from a restaurant. Witnesses called in that he was drunk and had pulled over, stumbled out of his car, urinated on the roadway and then fell asleep in the car. When police arrived, the body camera shows him absolutely hammered, stumbling. The officer asked him when he started drinking and he slurs out that he had started drinking at 9 a.m. It was about 5 p.m. He takes it to jury trial. His version of events in court was that he was driving sober, had pulled over, and then began drinking only once he was parked on the side of the road and therefore never actually operated the vehicle while intoxicated. Prosecution played the body camera of him hammered and stating he had been drinking since 9 a.m. The prosecution focused the jury's attention that the video statement and his in-court statements obvious both weren't true. His attorney stated that since he was so intoxicated in the body cam video that it was unreasonable to believe that he was telling the truth when he said in the video he had been drinking since 9 a.m. and that his in-court statement was more credible. He essentially argued that you couldn't convict him of being too drunk to drive based on the evidence against him because he was too drunk to make the evidence against him credible when he made the statement against himself. And they fucking acquitted. Tam said, I had one where a client was contesting a will. Halfway through the case, the other side argued that my client was set to inherit less without the will. If we won, then she would with it. If we lost, and argued she lacked standing to attack the will. The decedent had a very old will that benefited our client's deceased mother, but that will had been revoked. We found a very old doctrine in a footnote to something else entirely and argued to the judge that the law assumes you'd rather die with an old, revoked will than with none at all. Therefore, we argued he should look back to the prior will. Since our client would inherit her mother's bequest under the prior will, he held our client had standing to bring the will contest. We ended up settling the case shortly thereafter. Thepidor Now Speaks said, I think it's often where you have new wives' husbands and therefore step-brothers' sisters. Your dad makes a new will while quite ill, then dies not long after. Stuff goes to your stepmom. Then she dies and leaves it all to your step-siblings and you get nothing of what was your dad's. You might want to argue that your dad created his will when he lacked capacity, that he was coerced or whatever. Or everything gets left to your brother but you get nothing, for example. Sure, not all probate disputes are as mean-spirited or based on greed. I think most are about what's actually fair.